Greetings of the day. It's Anusmita Roy, and I'm going to discuss about the particular topic of strike under Industrial Disputes Act 1947. Before diverging into this particular topic, we will first begin with a short introduction, which states as follows. Like one vital piece of legislation that governs the Indian labor law with regard to trade unions and individual workers engaged in any industry in India is the Industrial Disputes Act 1947. It was put into effect in order to provide access to tools and machinery as well as procedures for investigation and resolution, irrespective of the size of the industry. Labor strikes in India are not uncommon and they occur across various industries and sectors. These strikes are often a result of disputes between workers and employees regarding wages, working conditions, benefits, or other likewise issues. The number of labor strikes can vary depending upon the prevailing socio-economic and political factors in the country. This right to strike is acknowledged by the legislation as a statutory right. It also established requirements that must be met in order for a strike to be legitimate, and any violation of them would regard the strike as unlawful or illegal. So, strike under Industrial Disputes Act 1947. For strike under this particular act, there is a particular definition section, that is section 2Q, which defines strikes as a cessation of work for a body of persons employed in any industry acting in combination, or a concreted refusal or a refusal under a common understanding of any number of persons who are or have been so employed to continue to work or to accept employment. In the famous case of Cox and Kings Limited versus their employee 1977, the court held that a strike can be considered justified if it is in connection with a current labor dispute or directed against an unfair labor practice of the employer. Constitutions stand on the legality of the strikes. Contrary to the international law, where the right to strike is generally considered as a fundamental human right, but here in India, right to strike is not expressly recognized by the law. It is not an absolute right, hence exceeding this right comes with reasonable restrictions which are being imposed by the state. Entry 29 in list 3, which is a concurrent list of seventh schedule of the Constitution of India, deals with the idea of trade unions, industrial and labor disputes. Entry 26 of the concurrent list deals with the matter of industrial disputes concerning union employees, empowered the central as well as the provincial and presidency legislatures to legislate on like various matters. So along with that, both the Indian Constitution and the Industrial Disputes Act 1947 are on common grounds. Both of them think that the right to strike is a legal right, and the sustainment of this right comes with reasonable restrictions. The significance of the right to strike is the core of significance to the principle of collective bargaining of each worker. Hence, the Constitution provides a guaranteed fundamental right to association and union under Article 14 of the Indian Constitution, but it doesn't provide the fundamental right to go on a strike. To till date, it remains an disputable topic whether the right to strike is a fundamental right or not. No clear view has been provided by courts on strikes, but one thing is clear and cut, that the right to strike is a statutory implied with certain restrictions. So, in the conclusion, we could state that it is observed that a strike is not a fundamental right in India, and government employees have no right to go on a strike. Industrial Disputes Act 1947 limits the right of strikes and gives them the legal right to go on strike as stipulated in sections 22, 23, and 24. The right to strike under the Industrial Disputes Act 1947 is very much limited and regulated. Thank you so much for your time.